And then we have a special speaker for today, Professor Courtney Hillebrecht. Right? That's correct. And Courtney Hillebrecht actually wrote an excellent book. This is it is titled Domestic Politics and International Human Rights Tribunals. This is a new book published in 2015, I guess, 14. Professor Hillebrecht is an assistant professor in the Department of Political Science at the University of Nebraska-Lincoln. And her research focuses on human rights and international relations, international law, and her work has been published in some prominent journals like International Human Rights Quarterly and Human Rights Review, and the Journal of Human Rights Practice. And she's been involved with a lot of projects that focuses on international criminals accountability and global peace. And she's going to address the audience today, international human rights courts. International human rights courts are important, and what's more important is how to facilitate compliance with the rulings of international human rights courts. And I think what's even more important is how to make domestic actors respond to the pressure from these international authorities. So this is why Professor Hillebrecht, in her work as well as in her talk today, will focus on the nexus between domestic politics and international human rights courts. Here's how we are going to proceed for today. She's going to give a talk for about 40 minutes, and followed by a quick follow-up from Professor Patricia Getty for about 5 minutes or so, 2 minutes, 2 to 5 minutes. And then we'll open it up for the floor discussion. Before we begin, let me quickly acknowledge the support we got for this special event. We got the support from, obviously, SSK Human Rights Forum, which is an organizer, and the other is Human Asia, which is the leading NGO, human rights NGO in South Korea. And Professor Seo is in charge. He is representing Human Asia. And the other sponsor was the Sungkyunkwan Sociology Department, which carries out the so-called BK21 Plus, which is designed to train graduate students. So they provided the generous support for this event. Okay? So now let's welcome the speaker, Professor Hillebrecht.
on Backlash to those same tribunals. Before we get started though, I want to talk about a theme that we're seeing, at least in the United States, in discussions about human rights, which is, are human rights in crisis? So if you look on the bookshelves of most human rights scholars, you'll see that this world is falling apart and the sky is falling. Human rights are in peril. This is the end time of human rights. Right? Human rights are in crisis. And I think, I think that there is a real debate about the degree to which human rights in this post-9/11, post-Arab Spring world are in fact in crisis. And so we see on the one hand the human disaster in places like Aleppo, right, which critics of the Human Rights Project are saying is proof that human rights as an effort to protect human lives, at least human rights with a capital H, capital R, have been failing. They might also point to the same building, this is the Human Rights Council in Geneva, and say, look, we're spending all of our time and energy in institutions and human rights laws while people are dying. But my argument would be that if we focus only on these big picture questions, right, are human rights in crisis or are they not, it's too easy to cherry pick particular pieces of data. It's easy to say, well, look at Aleppo. This is a human rights crisis. Right? It's easy to pick out the bad examples. We know that the news is attracted to them. We know through psychological studies that we're attracted to bad news. And maybe that's not the right conclusion, or maybe it's just not a conclusion we're reaching with enough evidence. So my argument would be that before we say that human rights are in crisis or not, we need to go down to a level where we can actually make empirical assessments. Okay, and here's some puzzle pieces, I think, that fit into the ways in which we can make empirical assessments about human rights. And maybe this maps on to some of the work that you all in SSK are doing as well, some of the different projects. I think we have this fundamental idea of human rights, right? What are they? The philosophical underpinnings of those. That's one piece of the puzzle. We also have public perceptions about human rights. And I know that's something that you here have been working on very diligently and very importantly. We have international and national human rights laws. And then I'm going to suggest that the fourth piece of the puzzle, or at least the puzzle I'm going to talk about today, is human rights and international criminal law, tribunals, and enforcement. This is just one piece of the puzzle. It's not going to solve the debate about whether or not human rights are in crisis, but maybe it can start to answer a little bit of the puzzle about what's the status quo of human rights now in 2016. Okay, when we're talking about human rights adjudication, I'm talking about 4 different concepts, and I'm going to speak to the first 2 today. But in the Q&A, if you have questions about the other 2, I'm more than happy to address them. So we'll talk about compliance, which is fulfilling specific mandates and orders by courts. We're going to talk about backlash, which is political and sociological and economic restraints against these courts. There's also legitimacy, how publics, how stakeholders view these tribunals. And then there's also effectiveness. Are these courts actually doing what they're supposed to do, which is protect human rights? So we'll talk about the first 2 because I think they feed into the second 2. And then in the Q&A, if you have questions about legitimacy or effectiveness, I'd be more than happy to chat with you about them. All right, let's start by getting the basics down. So I'm going to talk about 2 different types of courts today. The first are human rights tribunals, and these are regional courts. So there's one in Europe, there's one in the Inter-Americas, and there's one in Africa. I'm just going to focus on the first 2 for the talk today. In these tribunals, individuals, so you and I, can bring complaints alleging human rights abuses against our government to these courts. Actually, I can't because the United States is not a member, right? And you can't because there's no court to which South Korea is a member. But if I were Mexican, or German, or Turkish, or Russian, or Colombian, these courts are available to you. They adjudicate on a wide range of human rights issues, from property and privacy rights, to torture, to inhumane treatment, to femicide, a wide range of issues. But they have weak enforcement. They require states, the same governments that are essentially the defendants in these cases, to enforce the laws against them. Okay? So that's essentially asking a prisoner to punish him or herself. The other type of court that I'm going to talk about are international criminal tribunals. And the difference between the first type of court, those regional courts, and these criminal tribunals is that the criminal tribunals are trying individual suspected perpetrators. So these are war criminals. This isn't the government of Sudan, it's the head of state. Right? So these are individual criminals, and there's a variety of them. They're both standing and ad hoc. Standing would be permanent, so the International Court, Criminal Court. Ad hoc would be something like the Special Tribunal for Lebanon, right? Once it deals with this particular crisis, it's going to shut down. These states have a question, or rather these courts have problems with cooperation. Right? The enforcement is about getting states to cooperate, to turn over perpetrators, to arrest them, to turn over evidence, to allow the courts to interview victims and witnesses. So here we're really talking about cooperation problems. The first I'm talking about compliance problems, with these I'm talking about cooperation problems. That's just the general lay of the land, these basic courts. And now I'll talk a little bit more about compliance, that first concept that I talked about a couple minutes ago. All right. This picture, if anybody does Latin American politics, is pretty famous. This is from an abuela, a grandmother from the Plaza de Mayo. This is a group of women, along with the madres, who march every third and have for almost 40 years to try to find the fate of their sons and daughters and grandsons and granddaughters who were forcibly disappeared by the Argentine military junta. Okay. So they've been marching every week, trying to find out where their kids went. And recently, in the past decade or so, we've had a number of cases at the Inter-American Court of Human Rights, a number of processes at the Inter-American Commission on Human Rights that have pushed the Argentine government in various ways to repeal amnesty laws that protected the perpetrators of these forced disappearances, and to help these individuals find their lost loved ones. Now, the loved ones are dead, right, for the most part, but to find out their fate. So compliance matters. I'm going to tell you what it is, compliance with these human rights courts, and then why it matters. When I talk about compliance, what I'm talking about is fulfilling court-ordered mandates. So groups like the Madres, or even one individual can take a petition to one of these regional human rights courts, and if the court rules in their favor, the court is going to give the state a long list of items that it needs to do in order to be in compliance with this particular ruling. It's going to ask states, most importantly, to change or strike down laws, maybe to pass new legislation, maybe to create new courts for victims, to pay money to the victims or their victims' families, to build monuments, to apologize, to publish the rulings, right, to retry any faulty trials, to hold perpetrators accountable, right, even to do things like send the next of kin to college. The list of reparations is huge. And the court, particularly in the Inter-American system, less so in Europe, is very, very specific about what states need to do. My question is, why do it? Right? This is very expensive. This is politically difficult. Right? Why do states do this? I'm most interested in these measures of non-repetition. Right? This is where these tribunals can have a real impact. Because in places like Peru, when a law makes sure, or when the court rather tries to encourage the state to create a law to make sure that you can't be immune from prosecution if you attacked a prison. Right? This is a big case called Barrios Altos. Right? This has a fundamental effect on how politics work in that country. They make sure violations don't happen again. So this is where these tribunals are really impactful. The tribunals are really designed to be a last resort. They're designed to provide recourse for individuals who can't get legal recourse at home. And in doing so, they become a platform for wider human rights reform. But it only happens when states comply with their rulings. So if we have a ruling in Turkey, for example, about not torturing prisoners, right, that ruling can only take effect if, in fact, it's complied with. Non-compliance means there's no remedy for those individual victims. Non-remedy means that there can be more and more of the same violation. And it also means that there's an increase in the court's caseload. I'll give you the example of Italy. Italy has thousands of cases before the European Court of Human Rights. Not because it's the worst human rights violator in Europe, but because it has a very slow judicial system. So you're looking at about a 15 to 20-year time frame between the time you submit your complaint and actually get a trial in Italy, which in turn has led individuals to take their cases to the European Court of Human Rights. 99.1% of those cases all deal with the delays in the judicial system. Has Italy changed that judicial system? No. So what happens is every year we get thousands and thousands of more petitions. Okay? So that means that the court can't do its work because it's bogged down in just a few of these repetitive cases. Okay? So compliance is really important. Why do states do it? So how many of you are political science students? Okay. So for those of you, how many of you are law students? Social students? People who accidentally ended up here today.
Business administration? Economist?
A variety, great. Okay, so political scientists, especially Irish scholars, we like to think about compliance as falling into three different explanations. One is that international law doesn't really matter, right? All it does is codify existing practice. So if states are going to torture or not torture, international law isn't going to change that. So the non-torturing states get together, say, sure, we will create a law that says we won't torture because we're not doing it anyways. Okay? So in that case, the laws or the court's rulings aren't doing anything to change state behavior, they're just codifying it. Others, constructivists, are going to say that international law and courts create new norms, new expectations for behavior. A third group, which we would call neo-institutionalists or neoliberals, and I generally fall into that camp, would say that international law does constrain state behavior, but, and this is the important but, it needs to intersect with domestic politics in order for that to happen. So, over the past 15 years, there's been a long literature on how international law intersects with domestic politics, and political institutions in particular. What we've learned, right, is that they matter. Okay, that's important. Number one, they matter. They matter in a couple of different ways. They provide accountability for domestic actors. They provide the capacity to deal with international legal and tribunal requirements. They provide transparency, right, in terms of voters knowing what's happening. These domestic institutions matter. But if we're just looking at this as a pretty static relationship, do they matter or not, it's not telling us a whole lot about why or how states actually comply with these rulings. So what I'm trying to do here is explain why compliance is a domestic affair, okay? Compliance even with these international tribunals, and more importantly, what domestic actors can do to fill in this enforcement gap left by the courts. So tribunals, we can say, lofty goals, right? The European Court of Human Rights in the wake of World War II was designed to be the conscience of Europe. That's a lofty goal. But it's really lofty when you're trying to convince the Russian government that it needs to pay out millions of US dollars to victims in Chechnya. Okay? So there's weak enforcement, lofty goals, and they rely on this principle of subsidiarity, letting domestic actors implement the law and the rulings as their domestic context requires. Okay? So what the tribunal, what domestic actors rather, can do is start to fill in this tribunal enforcement gap by creating coalitions, pro-compliance coalitions of legislators, executives, NGOs, the media. And they can do these main things required of them to strike down old laws, pass new laws, agitate for policy change. Right? But we need this coalition of domestic actors to fill in the enforcement gap. So I think there's three explanations, three arguments really, for why domestic actors might form these coalitions to fill in this enforcement gap, to encourage compliance with human rights tribunals' rulings. The first is to advance domestic policy initiatives. So I'm going to talk about Argentina in more depth in a second. But here's this domestic push to find out the fate of these forcibly disappeared young people. Like, all these college kids were forcibly disappeared. Everyone wants to know their fate, except for the military, right? Except for the people who disappeared them. So you have a potential block, right? You have a major veto player who does not want this to happen, but a tribunal's ruling in a case like this can help political elites overcome that veto, give them the extra initiative they need and the cover they need to advance domestic policy initiatives. We also see compliance, I would suggest, as a way to signal a commitment to human rights. So Colombia's former president, Álvaro Uribe, who's now back in the news if you're following Colombia, he was using compliance with the Inter-American Court of Human Rights, and Colombia just got slammed and slammed and slammed by the Inter-American Court for, again, forcible disappearance, the use of paramilitaries to fight a guerrilla war, and so on and so forth. Uribe kept saying, look, we are committed to human rights. Look how well we're doing with the Inter-American Court of Human Rights. Right? We're signaling our commitment to a broader human rights framework by complying with this court. A third mechanism is to uphold long-standing human rights commitments. And I'm going to talk a little bit about the UK, who begrudgingly, whiningly, complainingly has complied with the European Court of Human Rights because of a long-standing commitment to the idea of human rights, even though it disliked, and in some cases despised, individual rulings. So I won't talk too much about the signaling argument going forward, but I'll give you a little bit more information on both the Argentine and British cases. Before I do that, though, let me tell you about my overarching research design. And if any of you are working on research projects, I'm happy to talk about how you do mixed methods research and how you get the pieces to fit together. So I did three main things for the book. One was large M analysis. I hand-coded far more than I care to admit cases of compliance reports, which led to over 1,000 non-repetition of those mandates to change the laws. I also did case studies across Europe and the Americas, and I did interviews. I asked people working at these tribunals, why do states comply? Why don't they? Who are the actors? Who's the veto player? And so on. So that's the overarching research. I'll tell you a little bit about the quantitative data before I jump into the case studies. So this is just those measures of non-repetition. But we have about 730 cases where there's been non-compliance with measures of non-repetition in the European Court of Human Rights. So 730 examples, and this goes up to 2008, the number has since grown, of states saying, no, I'm not going to comply with this recommendation to change your rulings, with this recommendation to create a new court system for victims of domestic violence, okay, for example. We have only 38% compliance. What does this suggest? It suggests that any rosy pictures of 100% compliance that used to prevail in Europe, especially before the early 2000s, are not true. The inter-American system looks even worse. Right? We have 77% of cases are not complied with. That means only a quarter actually get compliance on the petition where it matters most. Now, I said that one of the arguments in international relations theory is that domestic institutions matter, and they do. So just using some econometric analyses, we see these predicted probabilities, right? So the likelihood of compliance increases really dramatically from 10% to 48% as we go from weak democratic institutions to stronger ones. But that's only 48%, right? So maybe domestic institutions are necessary, but they're not going to be sufficient. Okay? And to understand what puts us over the edge, we need to dig a little bit deeper into the cases. So I'll go to that first causal mechanism of advancing a policy, and this is what we have in Argentina. So Argentina was a really unique case in that in the 1980s, maybe not so unique actually, but in the 1980s, there were 2 amnesty laws and a handful of pardons that smoothed the transition to democracy from the military regime. Okay? And those continued kind of okay throughout the 80s and into the 90s. But in 2001, the Inter-American Court of Human Rights passed a judgment against Peru. And it was called Varios Autos, and it said that there can be no amnesty laws, period. Now, this was against Peru, but, and this is the important part, the Inter-American Court's rulings apply to all member states, including Argentina. At the same time, there had been a new case brought forward in domestic courts by one of those madres to try to find her grandson. Okay. And so there was a new sort of political moment to actually get some information and to start to try those military personnel who had done this forcible disappearance. However, in 2001, the peso crashed. There were 5 governments in 30 days, right? And Argentina went through a whirlwind of a political process. But when it came out the other side, right, it actually took some really big steps to change its laws. It changed and repealed amnesty laws. The AG's office, the Attorney General's office, confirmed what the judiciary had originally done. Rescinded pardon, which was really big in 2005. The legislature went so far as to annul the Military Code of Justice, which previously had provided some shadowy accountability, right, for perpetrators of military crimes. Right? And civil society pushed and pushed and pushed for each of these changes. What we see happening here is under the guise and under the empowerment of an Inter-American Court's rulings, even against another country, the Kirchner administrations were able to push forward a policy change despite real reluctance by the military. So this provided an opportunity to advance a policy change that had a real challenger domestically. On the other hand, we have the British case. So the UK, and we'll talk a little bit about Brexit, but the UK has always been skeptical, not just of Europe, but also of the European Court of Human Rights. The European Court of Human Rights is a Council of Europe institution. It's not part of the EU, okay? But still the skepticism has prevailed. And when the UK got very involved in the War on Terror, the European Court of Human Rights got stuck in the middle of a security versus human rights debate within domestic politics in the UK. And on the one hand, the UK was pro-international law, pro-human rights, and it has been supporting these issues in its foreign policy, right? Very clearly part of its foreign policy program. But domestically, there was real pushback against the European Court of Human Rights, particularly when the court was ruling on things like who could or could not be extradited, detention without trial, right? Search and seizure, right? All of those security, human rights infringements that we think about as part of the larger War on Terror. So what happens, I think I'm missing a slide, but what happens, I'll tell you anyways, is that the UK has been complying with the European Court of Human Rights. But along the way, it complains and complains and complains, and justifies its compliance to its own domestic audience in this way. We don't want to do this, but we have to, right? The UK has always respected human rights. See the Magna Carta, we have to. And that kind of begrudging compliance has in fact led to compliance on paper, but it's led to a larger phenomenon that I'll talk about in a second, of backlash. So in my book, I was very wrong, because I'm pretty sure I had a line that said the UK would never back out of the European Court of Human Rights, because that would mean it might have to back out of the EU. So I'm in good company in not having predicted the Brexit, but I was wrong nonetheless. So when the UK says that it's going to back out of the European Union, it's also signaling to the European Court of Human Rights in Strasbourg that it might very well back out of the European Court. Again, the European Court is not part of the EU, right? But the two sort of operate in tandem. There is no EU member that is not part of the European Court of Human Rights. There are many, many European Court of Human Rights members who are not in the EU. There's 50 members of the ECHR, from Turkey, Russia, Azerbaijan, etc. Okay? So when the UK signals, you know, we're not really such a fan of this court, we want to back out, it also is signaling to other countries that they can do the same thing. So Italy recently has announced that it's only going to be complying and taking seriously Grand Chamber judgments of the European Court of Human Rights. So that's the same as saying, you know, this district court, I don't really buy it. I'm only going to take seriously rulings from a federal court. Okay? You can't really pick and choose like that. Russia, who has always been difficult, has said, well, if Italy is going to do that, then we're going to do that too. And they've instructed many of their judges to flat out ignore the European Court of Human Rights. Okay? So this is a form of backlash, of pushback to these tribunals that we're seeing in Europe, but that we're seeing elsewhere. The Inter-American Commission on Human Rights barely has enough money to keep its lights on. So over the summer, it was facing laying off 40% of its staff. Because countries were donating not $4 million, not $400,000, but something like $40,000, right? 1 year for major countries. Okay? That's not enough to keep the lights on, and it's not enough to let the Commission or the Inter-American Court of Human Rights do its work. This was not accidental, right? It was intentional. In the International Criminal Court, so one of those criminal tribunals I talked about, we have what they call in hushed tones and in quotation marks, the African problem, right? This pervasive sense that African states are going to withdraw en masse from the ICC. In the Special Tribunal for Lebanon, we have witness intimidation. A newspaper published the names, addresses, phone numbers, pictures of 14 witnesses. So if you were a witness against an assassination case, how would you like to have your name and all your contact information posted in the newspaper? Would you feel very secure? That's the one job of a court, is to keep its witnesses safe, right? And when they can't do that, the court doesn't seem very legitimate, and it can't do its work. Right? So these are all examples of what I'm going to call backlash. Okay, so let's talk a little bit about backlash. And I'll tell you about 3 defining features. 1, sustained action. So by backlash, what we're really talking about is not just one example of noncompliance, not just one example of a state pushing back, but a pattern of sustained resistance. Okay. Also, that resistance has to be directed to be qualified as backlash at the tribunal's moral and legal authority, and target its ability to do its work. Right? So it can't just have the tribunal be part of a larger tantrum, essentially, but its activity has to be directed at the tribunal, and it has to go beyond simplistic sovereignty claims. Right? We've been doing international tribunals in some capacity since the end of World War II. Right? The International Criminal Court has been in existence since 1998. Right? This is not just about sovereignty anymore. Backlash claims have to be more specific and sophisticated. Now, what's at stake with understanding backlash, and this is new, so I really welcome feedback and comments, what's at stake here is that these tribunals are the cornerstone of international human rights and criminal legal development over the past 50 years. And as we saw with compliance, they can have really important effects on domestic policy. But if they're constantly under attack, then they're not able to do the work that they need to do to actually improve human rights practices. Okay, inductively, I've been working on this inductively right now. There's about 4 different types of backlash that we see. One is withdrawal, or the threat of withdrawal. So that's saying, if I don't like this court, I don't like the way this court rules, my state is going to withdraw from it. But guess what? If you have lots of states who are constantly withdrawing or threatening to withdraw, it looks like your court isn't very strong. Right? It undermines your court's authority. Another form of backlash is undermining the legal framework by working within the legal framework. And I'll talk about the Kenyon case a little bit. So that's not showing up to court. That's not flouting the court. That's working within these tribunals' own systems to undermine them, to chip away slowly but surely about their legitimacy and moral authority. A third form is to engage in financial and administrative restrictions, so cutting the budget is a good way to do it. And the fourth is to advance alternative forms of justice. So Venezuela doesn't like the Inter-American Court of Human Rights, so it's going to create its own immune sword. Kenyatta in Kenya doesn't much like the ICC, so along with Omar al-Bashir and Paul Kagame from Rwanda, they're going to create their own court. Okay? So these are 4 different forums that I'm working with right now. I think we see backlash for 3 main reasons. One is institutional power process. When I said at the opening that there's a debate about whether or not human rights are in crisis, I do think that there is a debate about the legalization of human rights and the adjudication of human rights, and whether or not that is in crisis, or whether or not there's as much unanimity on that idea as Western liberal states felt it was. And I think there is not as much unanimity as the Europeans, and to some degree the Americans, although we can talk about the US position as well. It's kind of outside. Another explanation is domestic winners and losers. These tribunals, whether it's a human rights court or international criminal court, are going to promote some domestic actors, and they're going to make others domestically losers, right? I can't be in political office if I'm in a jail cell in Schweneninger in The Hague, right? There's domestic winners and losers. And I also think there's real public perception questions. These tribunals don't have great knowledge bases, and people don't tend to know about them. So when they don't view the tribunals as legitimate, it's really easy for political elites to manipulate them. I generally think the process is going to work like this, and this is something I'm still testing. The tribunal threatens prosecution, or starts prosecution, against a political elite, or against a government. The threat of prosecution exacerbates domestic schisms. This is on the second mechanism, on the winners and losers. It exacerbates existing schisms, okay? And then the accused can actually benefit politically, right? They can take accusations from a court, spin them into Western neo-imperialism, neo-colonialism, etc., right? Especially when the knowledge base among the population is low. And political victories of the accused can then further delegitimize the tribunal. This is what I'm calling tribunal capture. Still working through some of the concepts here. But I'll tell you how it plays out in Kenya, and then I'll wrap up. So in Kenya, for those of you who might not know the case, there was electoral violence in 2007 and 2008. And 2 political elites were indicted by the International Criminal Court, Kenyatta and Ruto. And they were on opposite sides of the post-electoral violence. But they both had one incentive, which was to protect themselves from going to jail. So they created an alliance called the Alliance of the Accused. That was the name that they used. And they run and won on a joint presidential ticket in 2013. So they have this domestic coalition, okay? And what they've been doing since 2013 is systematically undermining the ICC's case against them. Okay? They have engaged in witness intimidation, so we have witnesses that have gone missing, a lot of evidence tampering, evidence that's gone missing, failure to cooperate, but all slightly above board, right? So rather than Omar al-Bashir in Sudan, who just ignores the ICC, Kenyatta and Ruto comply, and they send teams of lawyers, and they do everything following the procedure, right? But all the while undermining the system through things like witness intimidation and evidence tampering. As a result of their non-cooperation, both of their cases have been dismissed. Right? They've been vacated. The prosecutor doesn't have enough evidence, right, to proceed, which means that the ICC has now spent almost a decade trying to try these individuals, right, has failed, and in the interim has created a storm from African heads of state saying that the court is biased and they want to leave. This is backlash. This is backlash, and poses a real problem for the ICC and other courts. But is it the end of the world for these tribunals? My argument here would be no. Right? My argument is no because we only see backlash when the tribunals actually pose a real threat. Okay? So the deeper the tribunals go into domestic law and to domestic politics, the more clearly they're setting up domestic winners and losers, the more we're going to see backlash. But in some ways, it's actually symptomatic of the tribunal's power, right, not of their weakness. Now, that doesn't mean that the tribunals don't have work to do, particularly the ICC, but not only. When you have courts that try to try heads of state, that try to rein in state behavior, but no superpowers are part of them? Of course, right? This is a very difficult setup. Right? This is not a consistent setup. So I think there's a political crisis, but not necessarily an existential crisis. Right? And I will stop there for questions. Oh, this is information about the new book, but